Thank you very much for attending this session, and I'm going to break from tradition a little today. Instead of beginning by welcoming and introducing our chief guest here today, in order to be, or not to be out of context, I'm going to speak briefly to give you an idea as to what is ICC, the International Chamber of Commerce, so that everything we talk about and people that we introduce to you, you understand who they are and where they stand with respect to the ICC. A few years, it's not a few years, it's just under 100 years ago, a group of businessmen got together at coffee and decided to establish something called the International Chamber of Commerce. They called themselves Merchants of Peace. And the vision that they set for the ICC was to establish or to promote peace and prosperity through trade. Today, the ICC is one of the, or indeed, in fact, the largest business organization in the world, with over 6 million members, 6 million chambers. It has recently achieved the observer status at the United Nations, a very, very interesting achievement that we could talk about later on if you're interested. And it has an executive board, which is the highest governing body of the International Chamber globally. This body consists of 17 directors from around the world. So 17 chambers from around the world have been elected globally by the 6 million chambers. And we are so privileged today that in our part of the world, one chamber has a member, has a director on that executive board. And that is Qatar Chamber. And the chairman of Qatar Chamber and the chairman of the International Chamber of ICC Qatar, His Excellency Sheikh Khalifa bin Jassim Al Thani, has been elected to be one of those 17 individuals on the executive board of the ICC, which is a great privilege for us. The ICC Qatar, and in close cooperation, of course, we work under the umbrella of Qatar Chamber, has closely been working with the global body, supporting some of its international trade activities. And one of those major achievements that we've had so far is our close association with the WTO, the World Trade Organization, which may be a little strange to some of you. But we have been supporting that organization, and His Excellency has been constantly working with them, supporting them, making sure that we as a chamber and as a country are in full support of global trade, because we believe trade promotes prosperity, promotes the well-being of humankind. So you can see that this little chamber in this little corner of the world is playing such a major role. And we are privileged today to introduce to you His Excellency Sheikh Khalifa, who's honored us with his presence today. I'm not going to say more than what I have said so far. All I'm going to do is introduce to you the managing director of Squire, Patton, Boggs, Mr. Sherbel Macaron. He is also the chairman of the ICC Qatar Commission. The ICC has commissions on national levels and on international levels. Sherbel is the chairman of the National Commission, and we have today among us also the chairman of the global ICC Commission, who will be introduced to you as part of the panel. And please allow me to welcome Mr. Shabal to introduce the panel to you. Thank you very much.
Assalamu alaikum. Thank you, Remy, for the introduction. Thank you for the history for ICC. I will keep my words very brief. We have very valuable information from our panelists, so I will not take too much of your time. First of all, I would like to thank Sheikh Khalifa bin Jassim Al Thani, who is the chairman of ICC Qatar, in addition to his role as the chairman of Qatar Chamber. Your support is invaluable. I think the crowd here today just speaks volume of the success that we're able to achieve with your support, Sheikh, so thank you very much. Thank you, Remy, as well, Managing Director and Board Member of ICC. You've been instrumental to the work that we're doing. Before I speak about today's session, today's presentation, just a very quick word about what we are trying to do as part of the ICC Commission in Qatar. We are tasked with the role of promoting arbitration, being a link between ICC and the business community and the legal community. We feel that we can achieve this best by spreading knowledge, by sharing the information we have, by sharing our experiences. So for that purpose, we have put together a series of presentations which we started last month and will run through May, so 5 sessions in total. Last month's session was sort of the starting place of an arbitration, which is how to draft an arbitration clause. And we had a good turnout. I see many familiar faces from last time and many new faces today, so we're delighted with that. Today's session is about party participation in an arbitration, and the gentleman here will speak a little bit about that. Next month's session, which is scheduled for March 12, I believe, will be on the new arbitration law, which we understand has been approved and hopefully will be gazetted soon. Our colleague, Mr. Sultan Abdullah, will be taking the lead on that next month, so we thank you in advance for your support. Moving on to the panelists, I'll start from the far right, Mr. Stephen Hibbert, General Counsel of Qatar Rail. Next to Stephen is Mr. Christopher Newmark, who is the ICC Global ADR Chair, and Chris flew from London specially for this event, so we appreciate his presence here today. Next to Chris, we've got Mike Mitchell, General Counsel of Qatar Foundation. And lastly, our moderator, Mr. Thomas Wilson, who is the Managing Partner of Squire, Patton, Boggs in Dubai, and also heads our construction practice in the region. So I'll leave it to you, gentlemen. Thank you very much in advance. And any questions, feel free to engage. This is really just to, as I said, spread knowledge, so please don't hold back. Thank you.
Well, thank you very much, Sharbel, for that introduction, and Remy for your introduction earlier. I am absolutely delighted to be here in this full room of interested arbitration students or participants or experts. And I want to commend the Chamber for this series, which is extremely important, I believe, to the education of the Qatar business community as to arbitration. And I want to commend the Chamber for this choice of topic. Our topic today is party participation in arbitration. And I emphasize the word party. I attend a lot of arbitration conferences and seminars, both in the region and around the world. And I find that the party's participation in arbitration is often overlooked in those conferences, and that's unfortunate. It's unfortunate because of all of the participants in an arbitration, the party is, or the parties are the most important participants. Any arbitration will have an arbitrator or perhaps 3 arbitrators, It will have an institution typically that is administering the arbitration, which is another participant, if you will. It will have representatives of the parties, lawyers or other representatives who present the parties' cases, and then the parties themselves. At most conferences such as this, the focus is on the institution, which institution one should choose, which rules are better than another, or on the arbitrators and the process of deciding a case and the requirements of drafting an arbitral award to ensure its enforceability, or on the counsel and the way in which they conduct a case, or on the procedure that the arbitral tribunal along with counsel follows for the case. But rarely, I would say, or certainly less often than one should, do we see discussion of the parties and their role in arbitration. So I'm very pleased that that's our topic today, and I'm pleased about that because arbitration itself, its very existence, depends on the parties. Without them, an arbitration would not exist. Arbitration as a dispute resolution methodology is fundamentally different from its primary competitor, which if you will, which is the court system and court litigation. It's different because the court system exists by governmental fiat. Governments create courts for a variety of purposes, including the resolution of disputes between private parties to commercial agreements. The courts exist for that purpose, and they are the default choice in any jurisdiction for the resolution of disputes between parties. Arbitration is fundamentally different because it exists only through the agreement of the parties to a dispute. Without the agreement of those parties, there would be no arbitration. Those parties thus give life to the arbitration, and they control the arbitration. They control the arbitral process in a way that I believe some parties have lost sight of because of the growth of this institution that we call arbitration, which to the minds of many has become a somewhat hidebound, ossified institution. It's certainly become a major cottage industry around the world with a number of lawyers like myself and arbitrators, such as some of my co-panelists here, who make a living through arbitration. And sometimes we can lose sight of the fact that these arbitrations, these processes exist only because of the parties, only because of their agreement, and that they are in control of that process from start to finish. But with that control, with that authority, with that power also comes a responsibility. A number of people, a number of parties to arbitration comment these days that arbitration has become too expensive and too costly, that it is no longer the efficient means of dispute resolution that it was, that it once was, or that it is marketed as being. And oftentimes that statement is true. But one thing that is important is to remember is that it is the parties who control this process, and it is the parties who are in the best position to lead a change or a modernization of the process that we have, to return it to the efficient dispute resolution method that it can be and should be. So I am delighted to be here today to talk about that process, to help educate some in our group as to the parties' participation in arbitration, to hear from other experts here as to party participation in arbitration, and of course, and most importantly, to hear from our august and esteemed panel. And before I turn to each panelist for them to provide their introductory remarks on this topic, I want to do just one thing. I would like to ask those in the room who are employed by or otherwise representing potential parties to arbitration to raise their hands. And I mean government entities who may be engaged in an arbitration. I mean companies who have been or may someday be engaged in an arbitration, or individuals who have participated in arbitration in any way. If you've been a party or might be a party, could you please raise your hand? Okay, good. So there are perhaps half the room are individuals who represent parties in arbitration. We're going to be interested to hear throughout the course of our panel discussion today from you and others about your views on arbitration and on the parties' participation in it. At this point, I'd like to turn to our panelists. I'm going to go first to Chris Newmark, who, as Charbel noted, chairs the ICC Commission on Arbitration. Chris also sits as an arbitrator and has done so for the past 10 years. That's his primary occupation, and he has given very extensively of his time to the institution of arbitration through participation in organizations like the Commission, which notably recently has produced a guide to parties for the participation in arbitration. We'll ask Chris to comment on the work of the Commission on that guide and give his own views as to this topic. Chris?
Thank you very much, Thomas, and good afternoon, everybody. It's a great pleasure to be here for the first time in Doha. It's a first visit for me. I hope to be back again, both for arbitration and in a few years' time to watch England win the World Cup. I, as Thomas said, chair the ICC Commission on Arbitration and ADR, and I'm going to use my introductory remarks to introduce this to you, this guide. There are copies of it actually outside, and you can also download it from the ICC's website. It's called Effective Management of Arbitration, a guide for in-house counsel and other party representatives. So as you'll see, it's directly on the topic of our discussions today. Just by way of background, a little bit about the Commission, as you may not be that familiar with it as a part of the ICC structure. The Commission, we describe ourselves as the rule-making body and the think tank of ICC. Rule-making in the sense that the Commission is directly involved in the production of new ICC rules of arbitration, mediation, disputes boards, expertise, all the dispute resolution rules produced by ICC, and think tank in the sense that we have task forces, international task forces, which work together to improve best practice in the world of ICC arbitration, ICC dispute resolution, and dispute resolution generally. And it was one of those task forces that produced this guide that I'm going to introduce you to. So the Commission is made up of members from all around the globe. We have about 800 members at present, all representatives nominated by their national committees. We meet twice a year, once in Paris, and our next meeting will be in April, and a second year in the fall, which is usually at the place where the IBA holds its annual meeting. So we were in Washington last September, and we'll be in Sydney this coming October. And between that time, as I say, our task forces are very active in working on various projects. I'm supported by around 10 vice chairs, and this region is represented by Issam Al-Tamimi from Dubai, who's an active participant on our steering committee. So, to this guide, this is one of a number of initiatives which ICC has taken over the last several years, really, looking at improving the efficiency of the arbitral process. You maybe have heard of the report on controlling time and cost that was published in 2007. And then we got through to the 2012 issue of the ICC Rules of Arbitration. One of the guiding principles in the revision of those rules was to improve time and cost efficiency. Then this guide came out, which I will talk about. And most recently, we've had the introduction of expedited rules of arbitration for smaller claims. And those rules, which take the form of revisions to the ICC arbitration rules, will come into force in just a few days' time on the 1st of March. So it's an ongoing process, and one that ICC considers to be extremely important because of what Thomas has been saying about the key necessity for arbitration to be a time and cost-efficient process. The guide was actually the brainchild of my predecessor, Peter Woolrich, who was the previous chair of the Commission, and he drafted it together with a task force which had, amongst its members, many in-house counsel who knew what was important to them in the conduct of international arbitration. Of course, when a dispute arises, parties are faced with all sorts of strategic decisions to make. The parties themselves know what is important to them. They know the underlying transaction, where it fits into their business, what's at stake, how much money is at stake, what other issues there are, and how much they want to spend on it. But there can be a challenge in marrying up those appreciations of their own business objectives with the choices that have to be made at each stage in the arbitral process. And that's really what this guide is here to help with. So for example, I mean, it's clearly faster and cheaper to have a 3-day hearing rather than a 3-week witness hearing. It's cheaper to have 1 round of written submissions rather than 3. But in each case, if you choose the shorter option, you're giving up that extended right to be heard. It's less expensive to produce witnesses for cross-examination by video conference. But if you have them in person at the hearing, maybe they will be more persuasive. The time and cost that a party is willing to devote to each stage of the case will, of course, vary according to the importance and complexity of the case. There's a cost-risk-benefit analysis that needs to be undertaken, and this guide is there to help party representatives, as well as their outside counsel, make those decisions. Outside counsel, of course, have an extremely important role to play, but perhaps over time they have taken on too much responsibility. Cases have been handed to outside counsel where they are left to get on with it with the tribunal, with party representatives, whether they be in-house counsel or a CFO or COO, taking something of a back seat. Well, this guide is designed to help redress the balance somewhat by making party representatives a little better informed about the issues. And when it comes to those really difficult cost-benefit decisions, a decision to give up a right to be heard, to engage in a shorter process, to pass up the chance to request for a particularly expensive phase of document protection, it is probably the in-house counsel or the party representative, if well informed, that is better placed to take that decision with advice from outside counsel. Because outside lawyers, understandably, want to do the best by their client, they want to win the case at all costs, and they want to leave no stone unturned. In-house counsel, party representatives, with a clearer view of exactly where the case sits in the strategy of the company, may be able to say, yes, go for everything, pick up every stone, we want you to absolutely spend all the money you need to spend on this case. Or they may say, actually, given the importance of this, we want it fast, we want it more efficient, we're prepared to leave out some steps in order to achieve that, and we appreciate and we take responsibility for the risk that may involve. So the guide is produced with the ICC rules of arbitration in mind. It dovetails with those rules, but it can be used as a guide effective for all sorts of arbitration, not just ICC arbitration. There are, at the beginning, some introductory sections and then three substantive sections. The first one is actually on settlement. There's no more cost-efficient way of resolving a dispute than to settle it. And there's reference there to ways in which settlement can be achieved through mediation, possibly ICC mediation, and also suggestions about the way in which you can involve the tribunal of an arbitration to facilitate settlement. Then there's specific reference to the case management conference. Case management conferences have long been used in arbitration, but they've become much more a permanent part of the fabric, and indeed they're now a compulsory part of ICC arbitration procedure. And it's a very important a time in which in-house counsel, party representatives can get involved by attending in person. I think we may come on to talk about that a little bit more later. And then the largest section are 11 topic sheets. And each topic sheet deals with a different part of the arbitral procedure. I won't talk about them all, but just to give you some example, there's a sheet on the request for arbitration, the answer, on the early determination of issues, so potentially splitting jurisdiction, liability, quantum, etc., on document production, on witnesses, and on the hearing itself. In order to give you a little flavour of how it works and the sort of ways in which it may, if you're a party representative, give you some guidance and some assistance, let's pick the topic of document production as an example. And each of the topic sheets goes through its own topic in the same structured way. First of all, there's a section, presentation, which will describe what the issue is. Here we're talking about the request by one party of documents that are in the sole possession of the other party, which they consider are necessary for a fair determination of the case. So that's under the heading presentation. Then you get the options. Well, what are the options in the context of document production? Well, there is the first option of no document production, which is not uncommon in many jurisdictions, perhaps less so in common law jurisdictions. Then there is the sort of international standard, if you like, of limited document production under the IBA rules of evidence and using techniques that are set out in that controlling time and cost guide that I mentioned. These are described. And then there is, of course, the option of much fuller document production, typical of a case that might be going through litigation or arbitration. So there's a description of those options. Then it takes you through the pros and cons, the cost-benefit. On the one hand, the document production process is likely to take time, it's likely to cost money. On the other hand, it may just be that the essential documents for proving your case are in the possession of the other party rather than in your own possession. Then there's a section on cost-benefit analysis. Can you meet the burden of proof for your case just using the documents in your possession, or do you need to get documents from the other side? A section on questions to ask. What extent of document production is appropriate? When should it occur in the process? What's the estimated cost, not just of producing documents, but also of reviewing documents and assimilating the information of documents that are produced to you? And then other important points to consider. Should you provide in your arbitration clause up front, before any dispute arises, should you provide a mechanism, a protocol for document production in the arbitration so that you know in advance what sort of document production procedures are going to be used? Should it happen more than once at different phases of the arbitration? When do you send documents to the tribunal for them to read? Should that be done just at the end, or should the tribunal be shown all of the documents that are being produced? Translations. How do you deal with objections to procedure in order to make the procedure efficient and not overly burdensome? How do you deal with electronic documents? So that's how this guide sets out the issues and the pros and cons to help a party representative who may not arbitrate every day. People typically in business, in-house counsel, even those specialists in arbitration, will be doing many other things in their day jobs. They may only do an arbitration once every 5 years, once every 10 years, once every 15 years. This guide is designed to be there so that when you come across that case, the new case, you can pick it up and become much, much more familiar with the concepts, with the choices, with the decisions, with the procedures that are going to come along, and perhaps have a more informed decision with your outside counsel and make some better decisions together that will lead to a more efficient and less costly process. My final comment will be just to go back to the case management conference and to say, if you are a party representative and you're the lead person giving instructions to outside counsel, and you hear that the tribunal has invited you to attend the case management conference at the start of the procedure, this is the one that's going to set the procedure for the entire arbitration, most likely. Please do accept that invitation and come along. Your outside counsel may say that it's not necessary. They may say, don't worry, this is procedural matter, we can deal with it, let's decide what's in advance, you don't need to come. Get on a plane and go. Travel to wherever it is and go, because it's your opportunity to structure, to retain possession of the proceeding, to structure the proceeding in the way that you want, to exercise appropriate control over your outside counsel, to engage with the tribunal, to show them that you're interested, and to give them direct input as to the procedure that you want for your arbitration. Many more things that I have to offer on this topic, but I'm going to stop there because I know time will require others to contribute as well.
Thank you very much, Chris. Before we move on, we want to make sure this is an opportunity for everyone to interact with the panel and ask questions they might have. So if anyone has a particular question for Chris, particularly in connection with the guide, I invite it now. Okay, well, I have one for you, Chris, just on your last point there. I know you sit as arbitrator quite regularly, so you will have seen these issues from the position of the arbitrator as well as from the work you've done with the commission. But on that last point of the party participation in procedural meetings, some might think that it's unnecessary because it is a procedural meeting. It's early in the process of the arbitration. It's not determinative of the substantive issues. Could you give some insights from the position of the arbitrator as how you've seen arbitrations develop differently depending on whether party representation was available and effective at the procedural meeting versus in the probably much more common case where it is not?
Yes, well, I can give a very recent example where I was holding as a sole arbitrator a case management conference, and the party representatives had attended this, and they were listening very carefully to the discussion. And I had a discussion with the outside counsel, two barristers who were representing their clients, about the procedure that we were going to adopt. And there were questions as to how long the hearing was going to be, how many witnesses would be needed on each side, whether we were going to have a procedure where each party would identify just the key witnesses that they needed for cross-examination, or whether basically all witnesses who had submitted witness statements would attend, and in which case whether there would be a much longer hearing. And we had discussions also about whether expert evidence would be necessary, whether we were going to have experts on the different laws that were applicable and experts on some of the costs and quantum issues. The party representatives heard all of this discussion, and I adjourned the case management conference just for an hour or so to allow counsel and their clients to discuss and reflect on what we had been talking about before then taking the decisions to decide the procedure. And when they came back, the claimant said, "I've had some clear instructions from my client on these items," and the client had quite clearly decided, having heard the discussion and also my input on it, that they wanted to go the more abbreviated route. They were happy to cut out some of those witnesses, to not have experts, to rely on fact witnesses. And the procedure was quite heavily influenced by the fact that the client was able to give that input immediately. Just one other quick example. One thing that a tribunal can do, and I'm not, I have to say, familiar with how much mediation may be used in Qatar and in the region, but one thing a tribunal can do is build into a procedure a window of where the parties have a chance to negotiate settlement, perhaps using mediation. And again, when party representatives are present and are given that option of, say, having a gap of a month or 2 months, sometime during the arbitration, perhaps after submissions have been exchanged and people know where they stand, I've found counsel not necessarily wanting that, but party representatives being very interested in it. And in fact, in one case the party said, actually, we've just had a discussion, the two parties had a discussion outside because they were present there at the case management conference, and they wanted the mediation window to start immediately after the case management conference. And it was the last I saw of that case because they settled the case through mediation without needing to come back. So I've seen it very positively, and obviously you don't know when just counsel come along, you don't know what might have been if party representatives had been there. But one thing I have had concern about on a couple of occasions is that the tribunal and my colleagues on the tribunal have been really ready and willing to move faster in the procedure. But counsel has said, no, we want 2 months here, we want 3 months here, we want a 3-week hearing, and it's good. Sometimes I'm worried, well, actually, is that because counsel want to turn every stone? Is that because counsel are very busy on cases? Or is that really because that's what their clients want? And sometimes having the clients there, I think, can make sure that you're getting the direct input as to what the parties themselves want out of the case and the timing that they're prepared to go with.
Thank you, Chris. And those examples that Chris gave are two excellent examples of party participation in arbitration, in the process of arbitration, in order to form that process to their desires, their needs, which may have conflicted with the assumptions that their counsel would have made, or perhaps even the arbitrators would have made without their presence. And I think it's important for us all to remember that dispute resolution, whether it be by arbitration or court litigation or some alternative dispute resolution method, in the commercial context at least, is a tool for the effective conduct of business. It is not and should not be necessarily an end in and of itself. And so, whereas counsel like myself will be focused, I think rightly, generally, on winning the claim that is being put forth or defeating the claim that is being defended, counsel are simply tools, and the process is a tool of the business, which may have other considerations in mind that will modulate the way that procedure is undertaken, and Chris has given some good examples. I want to turn now to Stephen Hibbert, the General Counsel at Qatar Rail. Stephen provides us a veritable hat trick of experience here, because Stephen is currently, of course, General Counsel, and that's a representative of a user of dispute resolution services, including arbitration, so he is a party. Stephen also has, prior to joining Qatar Rail, he had experience as counsel to litigants or participants in arbitration, both here in Qatar and beyond. And finally, Stephen also sits as arbitrator, so he has seen the process from all three of those perspectives, and of course is thus an excellent choice and panelist for this group. I want to ask Stephen to comment some on the dispute resolution provisions and contracts, how those are formed and negotiated, what he's seen to work and not work, and I believe he'll probably give us some insights on what happens in that regard at Qatar Rail as well.
Thank you, Tom. Ladies and gentlemen, very nice to have the opportunity to speak to you today. If I can just, before I make some observations, perhaps just give you a slight advertisement as to where we are with the project with Qatar Rail. Not my microphone, forgive me. Qatar Rail is the delivery authority for three major projects in Qatar. The largest, of course, is the metro, then there's the tram system at Lusail, and ultimately for the long distance program. To just give you a feeling for, and I'm saying this in the context of then commenting upon our dispute resolution procedures and arbitration clause. We signed our first contract in June 2013, and 3.5 years later, I can report to you that we have had 21 tunnel boring machines come into the country, construct 140 kilometres of tunnel, which is completed now, and then leave. We've got 37 major stations, 31 of which are underground on the metro station. And sitting here today, we're at about broadly the 58 to 59 to 60% complete. This is 2017, and towards the end of this year, if you happen to be travelling south of Doha in the Al Wakra area, you'll see the first set of carriages being tested on the elevated sections, the viaduct, which is called Red Line South, towards the airport. And all things being equal, we should have the opportunity to sell our first ticket to a member of the public at the end of 2018 for the metro. So in a period of just over 5.5 years, we've delivered one of the biggest projects that's ever been undertaken in the world. We're very proud of that. If I take you back to the workshop environment that we're in January, February, March 2012, when we were putting our contracts together, and the group at Qatar Rail that was involved in that, and I was involved in it, we were looking at this potential environment in the future, where our contractor packages, we've got about 8 major civil contractors and 1 big systems contractor delivering all the systems and the rolling stock, but that's our landscape on the metro project. We thought about both the dispute resolution procedures and, in due course, then the arbitration procedures. And consistent, I think, with what Chris has just said and Tom, there was a high degree of client involvement. There was a high degree of stakeholder input into what might work. And we formed a view that we wanted to tailor a dispute process leading to arbitration that was really consistent with the way we wanted to deliver the project. And there's not any great magic about it, but there are 4 key steps. And we're sitting inside a FIDIC yellow book inside clause 20, the traditional structure. So we said, okay, we'll have the 20.1, the claims process in the usual way. We tightened up the time limits a little bit, but that goes through to an engineer's determination. The first point of departure is, and after a lot of discussion, we decided not to have the DAB processes with a number of wise men sitting in judgment over a period of delivering awards. And that was partly because of the logistics, because we thought at one stage we'd have to find, upwards of like 15 or 25 very senior wise men to come to Qatar and do things in a DAB environment across 9 major contracts. And that whole model was a difficult one to work with. So we put in place a 2-staged almost mediation dispute resolution process. The first stage is when the contractor, or us, but the contractor files a notice of dispute. There's a period of 42 days, and then going on to 84, where representatives of the parties meet in a controlled environment with minutes and records to try and resolve the dispute. And if the dispute is not resolved at that stage, the next step is the dispute's elevated to what we call senior dispute resolution executives, which is CEO level. And there's a 60-day period where that process can take place. And when I finish this, I'll give you a little bit of a summary of statistically how often these sections have been accessed and where we are. We then looked at the final pre-arbitration step and thought we should have something before things go nuclear, in a sense, and it's pistols at 50 paces. We decided to put in an expert determination process which was binding on the parties until the arbitration reference took place. But we made the expert process opt-in. In other words, the parties had to agree that they wanted to have an expert determination on a certain feature. And we were thinking, there's no limitation, but we were thinking that the expert process would be more engineering and technical and less commercial and contractual. And so if there's issues about construction quality and they need to be dealt with, that determination process will be accessed. We then put in, I'm very pleased to say, Chris, we put in an arbitration agreement that's got the ICC as the nominating body. It's a simple, short set of procedures that says that the venue for any arbitration will be in Qatar, the language will be English, because our contracts are in English. The nominating body will be the ICC, and it's ICC Rules 2012. The only, I suppose, perhaps unusual feature about our arbitration clause is that we made the policy decision that arbitrations could not commence until the relevant works had been completed. And we made that policy decision on the basis that, for a range of reasons, but we thought, because we had so many multiple contracts, not as many as, say, the airport and other places, but we had 8 major contracts plus the 9th big systems contract, that the capacity of our organisation to deal with international arbitrations on multiple fronts at multiple stages was just impossible, that we just couldn't do it. And secondly, it wasn't to be difficult to the contractors. Secondly, we sort of wanted to send a message that really we wanted these major arbitrations, if there were to be any, to be after the works were finished and there could be an accounting. Now, I can tell you, when the bids were going in and the contractors were bidding for our projects, that was very controversial. It was very controversial. They said this is just, very unfair, keeping us away from arbitration. The proof of the pudding has been that, as I'm sitting here with you in February 2017, we haven't got one dispute that is anywhere near either the expert process, really, or an arbitration. We've got a couple of significant disputes. I know I've got some colleagues here who are involved in them in terms of acting for the contractors. There is one particular dispute that's been quite a significant one. But generally, for all of our contractors, faced with that landscape of the claim and then the parties meeting and other things, for all our contractors, there's been a healthy appetite to resolve disputes. And I do want to just, if I may, put an advertisement in for my management in this sense, that I've been involved in many major projects in my career over the years, and I can say that you should be very pleased of the management of Qatar Rail, because they have a very, very strong, active philosophy to resolve disputes as and when they arise over a period. And we as an organisation, generally have a sort of a 6 to 8 to 9 month philosophy of washing up our disputes as and when we can, and doing things on both sides to try and resolve them. And that's proved incredibly successful, because almost, I think, to every contractor in the world, none of them really want to end up on a major project, particularly a project that's got international publicity, particularly a project that's so significant for the country, and be the one who wants to take the organisation to an international arbitration. So if you combine all of those factors, that's our world and our landscape. And I think, sitting here today, I can report to you that it's working remarkably well. we should all get together in 2019 again, and I can give you an update and tell you how things go after we're finished.
Well, thank you very much, Stephen. And what Stephen's just described occurs to me as an excellent example of parties, and I would say in particular Qatar Rail as the employing party in its contracts, having spent quite a lot of time at the outset or before the outset of a project in formulating the process that it will use for dispute resolution in its projects, and I'm sure among a number of other competing matters that had to be dealt with at that time. Qatar Rail obviously put the time into the dispute resolution mechanism that was needed to form a mechanism that has worked for Qatar Rail and has worked at least for most of its contractors, I would say, if not all. Now, the important connection to arbitration there, in my view, is this. Without arbitration as the dispute resolution, the final determinative dispute resolution process, if, for example, without that, the decision were that the final process or dispute resolution process would have been in the courts, then there would have been much, I suspect, much more difficulty in controlling the timing of arbitration or the timing of that final dispute resolution process in the way that Qatar Rail has been able to do. So they have used the process of arbitration and the governing legal structure around it to help construct a stepped dispute resolution process that helps to resolve claims early, to resolve claims on a binding but not final basis through the expert determination, so that the process, so that the parties get on with the project, get it done. We all know that if the metro, for example, is just one of the projects, is not finished in a timely way, then there will be quite a lot of difficulties here in Doha, particularly around the World Cup when so many people will come to visit. So that is a project in which arbitration as an option has been effectively used to create a process for the benefit of the project. One question that occurs to me, Stephen, is that if I were advising a contractor 5 or 6 years ago who was looking to enter into a contract with Qatar Rail, of course I would have been concerned about those prohibitions or the prohibition on raising a claim in arbitration until after the works are completed. And particularly because, as anyone involved in the construction industry knows, that cash flow is the lifeblood of a contractor, and if there is a claim pending that impacts cash flow in a substantial way, a contractor will want and need to resolve that claim very early in order to assure that the cash flow needs are dealt with, or if they lose the claim, that they have other means to fund their project. Now, my guess is, since you have been rather successful with this, there must be mechanisms in place by which you're managing the claims as they arise very actively. Mm-hmm. Can you comment a bit on how you managed to do that?
And two things. Just on the cash flow aspect, again, possibly, and I say these things possibly because of the prominence of the Metro project in terms of the country and on the world stage. I'm not saying it was looked after in any particularly special way, but it was recognised that really, to get the best out of our contractors, they should have as close to neutral to positive cash flow. So our advance payment mechanism and our milestone payment mechanism was designed to be responsive to the work that's carried out, but also to give them a very good cash flow environment from the start. And that was spoken about and mapped and planned with them, et cetera, et cetera. So the ability of the contractor community to accept that dispute resolution process and its stages is wrapped up inside, holistically, the style of the contract and the payments and the milestones and other things. You can't just take that one example out and say that's the right model for somewhere else. In terms of the claims issues, I think that, as again, it's a credit to our senior management, but that right from the start, there's been full engagement, and I'm talking at CEO and MD level, on a daily and weekly basis, and very senior management, on all the details of the claims, and a philosophy of, we're certainly not a charity, and we're not easy as a client, but certainly that we recognise that if we have stepped in and issued a variation and we owe someone some money, then we should be accountable for it and deal with it. And that's perhaps a little bit different to some of the larger Middle East projects historically, but it's certainly had a good result. To the extent that I can see sitting here now that there are likely to be less and less and less unresolved disputes as we get towards the end.
Well, thank you, Stephen. There's some themes there that I want to return to a bit later in our session. But as we first, let's turn to Mike Murphy, Mike Mitchell. I'm sorry, I have a friend named Mike Murphy. Mike Mitchell,
everybody does.
The General Counsel of Qatar Foundation. Mike brings a different perspective as well. He's been in Qatar now for about a year as General Counsel of Qatar Foundation. Prior to that, Mike was Vice President and Senior Associate General Counsel at the Ohio State University in the United States. Ohio State, for those who don't know, is one of the largest public universities in the U.S. And one of the most respected Tier 1 research institutions in the United States. And there, prior to that, Mike served as General Counsel of another organization and was in private practice. So he brings experience from a very well-developed litigation culture in the U.S., where we have a well-developed court system and where arbitration is used more often as, or at least it should be more often, a more cost-effective alternative to litigation, but not the only alternative for dispute resolution. So I'm interested to hear Mike's insights on the differences he's seen since he's arrived in Qatar and as the General Counsel of an organization that is a potential user of arbitration and party in arbitration, and how that relates to his experience in the United States.
Well, thank you, Tom, and it's a pleasure to be here, Sheikh. I appreciate the opportunity to be involved in a panel of this level, and really encouraged to see the level of participation. A couple of things I want to start out with is just my observations relating to things that I've had to get used to from a dispute resolution standpoint. And you mentioned one of them is I'm used to a well-developed court system which actually worked in a very efficient manner in resolving disputes. Construction disputes particularly were primarily resolved through the alternative escalating dispute resolution mechanisms in the contract, and very rarely ended up actually in litigation. There was extensive effort put in, lawyers were hired on both sides, but matters were generally resolved in some way before court. My observation here, based on my own experience at Qatar Foundation and in talking to other attorneys and colleagues, other owners of projects, is you often end up in arbitration for other reasons. You end up in arbitrations because of payment practices. You end up in arbitrations because of an inability to reach a compromise, which is a result partially of, could be cash flow, it could be the inability of the client, the owner, my colleagues at an institution to make the decision to compromise a matter which doesn't necessarily feel comfortable from a dollar standpoint or real standpoint. So I think what I've seen is there's some arbitrations which almost are an unintended consequence of an off-ramp on a highway. So I think a lot of what we have to do, and it sounds like what the Qatar Rail has done, is designed off-ramps to avoid getting to a point where these claims will be filed. So you can complete your project so there's predictability for the business owner. My role in an arbitration, what I view my role as is may or may not be a little different than some of the other owners here, in-house people. I have a large legal staff. I have experience in this area, and therefore I have expectations about how I can manage counsel in an arbitration that may be different than a smaller team that doesn't have litigation or arbitration experience. So this idea of when you engage counsel, whether you turn the matter over to them entirely And I'm not sure there's a right or wrong model, but I see here basically handing the dispute and the matter over to counsel and saying, here you go, this is now yours. So the in-house lawyer washes his hands of it, really is not engaged fully in the management of the matter, but turns it over to counsel to bring it to whatever the conclusion is. That is not something I'm comfortable with nor used to, from two reasons. The ability to have off-ramps from a settlement perspective, as well as the ability to control costs. That's another observation I want to make. A difference that I've seen here that I've taken a while to get used to is, and I'm not saying it's good or bad, it's practice, is a flat fee or cap associated with an arbitration. So negotiating up front, whether it's through GTC or LTC or counsel themselves, like to have a capped fee, a flat fee, and they would prefer to do that instead of actually managing the matter on an hourly basis. I understand why that can happen if you don't have experienced counsel in-house. It's very difficult to actually manage the activities of a law firm. So the comfort of a capped or flat fee is there. But from my perspective, my job, one of the reasons I get paid is if there is a dispute, it is my responsibility to manage that dispute in a way which is most cost effective for my client. Not just at the top end, but what's happening on a monthly basis. And I'm not, and I don't want to denigrate any law firm that has represented the foundation or anybody else, but it's funny that they always hit the cap, right? So if they're left to their own devices and you're not reviewing on a regular basis the work being done, it is amazing that they'll never be under the cap. I don't know if you've ever experienced that, Steve. Chris, and frankly, if you're left alone and you're a lawyer, you will find the time to fill the vacuum and you will uncover every stone. You will do an not excessive amount of work, but you will do a very thorough job, in which I would do as a lawyer when I was representing clients. So that's another observation, is how do we manage the project? Another difference is, I view my primary role in arbitration, we currently have 3 pending. I'll talk to you in 5 years, Steve, and see where you are. And we've had a lot of projects delivered over the last 7, 8 years that are now been handed over and mature. So it is my job to inform my client. So I'm very fortunate to work for Her Excellency Sheikha Hind, who's the CEO of Qatar Foundation, and she is a data-driven business professional. So what she wants from me on any matter in reporting is details, risk analysis, risk-benefit assessment, how is it going from a financial standpoint. And I think you will all find that leaders, depending on your organization, have different appetites for the amount of information that they're willing to listen to regarding a dispute, how often they want to hear it. But I'm fortunate to have a CEO and a management team that I work with that wants to know this stuff, because they want to manage the matter in a way, and I use this term off-ramps all the time, is they want to be able to make decisions along the pathway which is most beneficial to the organization. So if we're a claimant initially, and we're moving along and things are going well, and the sled is going down the hill, and everything is building momentum to ultimately an ultimate determination, you want to have the ability, if things change during that process, to find a way off, to find a way to compromise or settle. And if you don't have active monitoring and participation within the organization, it is difficult to do that, because once the sled gets going, the momentum builds, and you end up in front of an arbitrator or a panel, and the decision's out of your hands. I mean, you do the best you can, but a third party is determining whether you get a check, whether you write a check. And frankly, from most business people's standpoint, that is not an acceptable management or mitigation of risk. So I like to be able to provide that information, and I'm fortunate enough to be able to do that. One of the ways that I can do that is something that you mentioned, Chris, is attending case management conferences. They would have to tie me down to keep me away from any proceeding, regardless of where it is. I mean, if it's London, that is not a hardship, right? It's nice to go to London occasionally, unless you're going 3 times a month and you have other work to do. But I think lawyers or business representatives should be at everything, including scheduling conferences or procedural matters. Because, as you say, there may be a different perspective of the business person. In the last case management conference I went to on one of our arbitrations, the other side's representative, when his counsel was arguing for a prolongation of time to respond to a matter, and they were arguing forcefully for that, he got up in the middle of the hearing and went and whispered in that person's ear, and they went back, and then the lawyer pulled back and went back to the original date. Because I think the dollar signs in the client's mind about how much time that would take, how much the lawyers would cost, I think it caused a spasm, and he got up and expressed himself. So I think that's an important one, active participation. Another thing I will mention was not entirely on topic, but I have a significant size staff. 80% of my staff is Qatari. And since these arbitrations are taking place, and I think will be for the next probably 15 years related to the amount of infrastructure and projects being built, these are training opportunities for the staff in my office. So every single case management conference, when we're deciding strategy and everything since I've been there, and this was before I got here as well, there are 2 Qatari lawyers who participate fully in all of it. They go to every case management conference because this is an opportunity to learn something. And you know, and one of the gentleman or young lady who's in those conferences is going to be the general counsel of Qatar Foundation someday, or Qatar Rail, or QP, learning about this so that they can advise the CEOs of in the future or of other Qatari entities, I think is really important as well. That's kind of my knowledge transfer requirement. And you can learn a lot by attending a CMC. You can learn what's important and what's not important regarding the fighting between counsel in front of the panel. And in having the experience and ability to understand what's important and what's not important. And I had one of the lawyers in my office say, well, it appears that the panel really likes us and our judges, or in our representatives more than they like the other side. And they went on and on about this and said, the lawyers were talking about this, and I said, that all may be true. And they may dislike the other lawyers clearly, and they may not like the witnesses on the other side or the representatives. But if you have a good panel, they're going to decide it entirely based upon the facts, the evidence, the law. You know, the town I used to live in, the best lawyer in the city was the most hated lawyer in the city. Everybody disliked him. The judges, the court clerks, he was rude to everybody, but he was the best lawyer in the city and won case after case. Nobody liked him, but everybody wanted him if they got in trouble in a business dispute as their lawyer. So I tell my lawyers all the time in the office, it's like, it doesn't matter. You know, it's nice. In the event of a coin flip on a matter, if they like my lawyer better than their lawyer, that's great. But I don't think that is meaningful. So these are just some of my observations. I'm learning a lot. I'm constantly learning. I think I could be here for 15 years and still not understand some of the business decision making that leads to arbitration or that avoids the arbitration. But I commit to continue to learn, and I'm really enjoying my time. So thanks, Tom.
Thank you very much, Mike. Again, I want to pause and ask the audience if anyone has any questions for Mike. I see one in the back left here. Sir, please stand up and speak loudly.
Since you've been here for...
Hello. General question to you. How do you overcome the cultural challenges here? For example, if you have a contractor who is claim-oriented, or if you have a client who he doesn't want to pay on time for a certain purpose. How do you overcome those cultural challenges? Because many of them, they are coming from different cultural backgrounds.
Sure. You know what I do? I try not to view them as cultural issues. I try to view it as the business environment, right? So what I would say is, in my experience, and I can say this in paying lawyers, and I'm sure Charbel will agree, is companies here are slow pay with their lawyers. Right? So you look at a receivable in the UK or the US, and to pay your lawyers is this, and you look here and it's this. I don't view that as culture, I just view it as the business environment. So that's where I start at. Acknowledging all of those is another place I start. So I learn these things and understand them, I think, without kind of judging or filtering. But you're right, they're different than what I'm used to, but I look at it as business environment. I don't know if that answered your question. But,
Thank you.
Sure.
Another question? A question down front on your right, please.
To the back.
Just a moment. There's a microphone coming for you, madam.
Thank you. My question is to Mr. Stephen about the construction contracts and the dispute resolution clause in the FIDIC or standard contract, which refers to the engineer as a sole arbitrator, and the parties should go, if there is any dispute, to be resolved by the engineer. If they didn't reach an agreement, they refer to the court. There is standard provision in the FIDIC like that. Does this clause stand as an obstacle to go for arbitration or arbitration agreement between the parties if they didn't want to go to court by the original contract they signed?
I think,
Yes.
Is that working? I think, maybe not. Can you hear me? No? Is that working? Yes. Forgive me. I think I understand your question. It's interesting because when we, I think in the formation of our contracts, which is possibly a little bit different. Under our contracts, the engineer is actually an employee of Qatar Rail. He's the chief program officer. So the engineer as a person is an employee of Qatar Rail. We thought that might be viewed as a difficult concept to work with by many of the contractors who are used to having the engineer being an external project manager or someone external to the organisation, etc. But in a positive sense, and I think this is partly because of the people involved, on most of our claims and claims resolutions, the contractor is always very keen to get an engineer's determination and to have that published and have it published with reasons and details. And I think that's mainly because, you know, contractors are reasonable people generally, and they want to see the analysis and see the methodology and see why things are disallowed or why certain values are reduced, etc., etc. And it is in our contract, in that process, that dispute process, that you've essentially got to get an engineer's decision to move to the next stage. So I'm not too sure if that answers your question, but does that answer your question? Possibly.
If the parties didn't agree with the
Engineer's
engineer's
decision,
decision, yeah.
then they can start the dispute resolution
Yes.
process, yes. But that's preserved as a step, and it's proved quite valuable. Yeah.
And I'd say the lady's question, just a moment, the lady's question raises a further point about party participation in the arbitral process. And we haven't touched as much on the party participation in drafting the arbitration agreement. We've heard from Stephen about what QRail did. And of course, that was across a suite of contracts. So I want to come in a moment to some questions for the panel here to consider, involving their ideas and their pointers, if you will, for all of us on how parties can seize control of the process at the earliest stage when the agreement is drafted. First of all, there's a question here in the front, sir.
First of all, I'd like to thank Thomas and Michael and Christoph and Stephen to be here with us at the chamber and to listen to the review about arbitration and participation in arbitration. I have just small question for you. Famous case with the rail is Musharraf.
Yes.
The contractor was, we contractor say was kicked out of site.
Yes.
And did that go for court or arbitration or mediation? What happened?
With
Famous case of Musharraf with Samsung and
the famous case so far of Musharraf.
everybody knows it, but yeah, we don't know what
Is
happened.
Sultan Abdullah still here? I don't know. The current status, yes, we had one unfortunate outcome with a major contractor where, and it's in the news and it's publicity, that in May 2016 we terminated their contract for Musharraf. Actually, it was Musharraf and Education City, the two major stations. Sitting here today, we have worked through the various disputes, the dispute resolution steps and their senior executives, and that's just concluding just now. It's taken some time. And the engineer is performing a valuation process of the works as at the date of termination, the work that was done, the reinforcing bar that was on the site, the plant and equipment, and that'll be published, and then we'll have to wait and see what the next step is.
Thank you. One thing I think we might warrant, excuse me, we have one further question down front.
With regard to the conflict conflict between contractor and clients, should the contract include specific clause for arbitration? Because generally the clauses in the contracts here refer to, in case of any dispute, you go to basically Qatari courts. Now, could it be taken for granted that the parties could go to arbitration prior to, or should that be specifically mentioned, referred to?
Do you want to do that? Well, I mean, I can make the comment. If the situation in Qatar is that if there is no arbitration agreement inside the contract, it defaults to the courts unless, when the dispute arises, we sit down and say, rather than go to the courts, why don't we give Chris a call and have the ICC appoint an arbitration panel, and we will agree to do an arbitration, it's called ad hoc, but for that particular dispute, and that's always available, and it's to be encouraged. But if the contract's silent, then ultimately the courts will take jurisdiction.
And that is a fundamental and very important question, in that it is imperative that everyone understand, as I noted at the outset, that arbitration exists only as a creature of an agreement between the two parties. And so if it is, in my view, highly desirable where two parties engage in a contract of any sort, to include in that contract, if they wish to opt for arbitration, to include in that contract a very clear agreement that they will refer any disputes to arbitration rather than going to the courts, which would otherwise be the default mechanism. As Stephen notes, it is possible that the parties who maybe have not done that in a contract can later, after the fact, once the dispute arises, agree to arbitrate that particular dispute. Unfortunately, what often happens is at that point in time, the parties are already adverse to one another in their relationship, and one party or the other will find or will posit that the court system would be advantageous to them, or the arbitration system would be advantageous to them, and often the two parties can't come to an agreement at that time. So it's important to have that agreement at the outset. It makes the use of arbitration much more likely. This is the question here, sir.
Thank you. Thanks for all the presenters. My question is for Chris. As you are aware that in Italy, the court system does not even see or look at any case before the parties go for mandatory mediation. All parties, they have to go to mandatory mediation. If it fails, then they can actually go to the second point, which is the court. In Germany, it is optional. In the UK, it is optional. Now, is there an idea within ICC ruling to actually make new ruling to force the parties to go for mediation before they commit for arbitration? That will just lower the pressure on the courts, will lower pressure on the bodies that actually manage the arbitration to push it for mediators.
Well, the straight answer to your question is no. There's no such initiative, and I don't think there is ever likely to be one of that type, requiring parties to mediate before they arbitrate. And one of the principal reasons for that is the motivation for that rule, as you again mentioned, in Italy and in other countries. It's because it's designed to relieve pressure on the court system, which is a publicly funded system generally, and which has limited resources, and so those resources need to be spent only on those cases which can't be resolved by agreement. And so the state decides to require parties to mediate first, and only if they can't resolve it by agreement can they use the very scarce resources of the courts. Of course, in arbitration, we're in a very different situation where parties are choosing to go to arbitration, and they're choosing to pay for that service, and there are arbitrators available who do have the time, or should have the time, to spend on the case, unlike a judge who has, you know, a docket which is trying to clear. So I think the dynamic and the imperatives are very different in arbitration as they are in litigation. That said, I've been a strong advocate for some time for improving the opportunities for parties to use mediation in the context of arbitration proceedings, either before or during arbitrations, to settle their cases, so that they are properly aware of that possibility. Because sometimes people get into arbitration and think, well, we're in this alternative process, we're not in the courts, we're in arbitration. And that's that. They don't fully appreciate that they have other options for settlement, like mediation, which they can use in parallel to their arbitration proceedings. You also have arbitrators who, because they're getting paid to do the work and would like it to go, and it's very interesting to go through to a final hearing, don't necessarily encourage parties to take the time out from the arbitration to go and appoint somebody else to mediate the dispute. So I think it's very appropriate, and the ICC is doing this through the rules and through its publications, encouraging parties to be aware of the option of mediation, but unless they've contractually committed to doing it, ICC is not going to force them to mediate.
Any other thoughts on that question from our panel?
Support this gentleman's question. I think it was very good, and a lot of international court systems are now putting mediation as a step, and I was just going to support you in suggesting to Chris and the ICC that you considered in your next set of rules that after the preliminary meeting you should be able to order mediation.
I will say that it is certainly common in Dubai, and particularly in the construction industry, to see clauses that require either mediation or conciliation, which is a closely related cousin, you might say, prior to sending disputes to arbitration. And it can be, it has been used at least as a bit of a double-edged sword. On the one hand, the intent is, and it's often realized, of course, to bring the parties together to urge an amicable resolution of the dispute through a third-party facilitated process, which can be very helpful, and I'm a great proponent of mediation.
So, but as an owner's representative, I would encourage this, and if I could explain why. It's based on my limited information, being here for 1 year. But what I see happen is, if the numbers are not close on either side, and the decision makers on either side, neither one, the claimant and the respondent, neither one feels comfortable going to their leadership and authorizing an acceptance of a lesser payment or the payment of more than their internal people are telling them, then nothing will happen until it goes to arbitration, because there is a fear that that is their decision then, which can be proven to be incorrect, and there can be retribution or problems for that. I think having a mediation step, whereas you get a kind of a validation of whether your people are right or wrong by an independent expert or an expert determination, I think would be valuable, because I think we end up in arbitration to get a third-party determination to make a payment we could determine to make ourselves, or to get something we could get ourselves. If there was a way to do that without a full-blown arbitration, I would encourage that, because it creates it's a third party that's determining the decision, which may make it easier for a GTC or somebody else to authorize payment, as opposed to acting on behalf of a recommendation of say, the responsible engineer and the lawyer internally. So that's, I actually like the idea of it. How it plays out could be different.
Well, the other side of the other edge of that sword is that particularly in the years and the many disputes that followed the global financial crisis, contracts with that provision were used by respondents who had not paid, typically because they didn't have the funds to pay, to delay access to the final award or the final justice, if you will, by first, of course, forcing parties through the mediation process, which is fine, that's what they'd agreed to, but then challenging jurisdictions of arbitrators on the basis that the process wasn't properly executed or what have you, and claiming that the completion of a mediation process was a jurisdictional prerequisite for the arbitrators to take jurisdiction in the case.
Poor behavior can never be
That's right.
dealt with
Poor behavior
based on words on a piece of paper. So.
Yes, that cannot be prevented, but the words can be drafted very carefully to try and prevent poor behavior. And this is another place where the parties can take control of their process and make sure that what they have agreed between themselves is what it is they want. And one of the questions I wanted to put to our panel here before we close, which I think is very important. We have here two general counsel of two very large and well-known Qatari organizations who have at their command, if you will, teams of lawyers and commercial people who do an excellent job, I'm sure, of advancing their party's interests in this process. Of course, we have Chris, who has a career's worth of knowledge and understanding of the arbitral process and the dispute resolution process through his own practice as a lawyer and then an arbitrator and mediator and his involvement in ICC. Unfortunately, most of the clients with whom I deal on a daily basis, or most of the cases I see in arbitration as arbitrator, don't involve parties who have that kind of expertise in-house and available to them when they negotiate their contracts. And as anyone who works within a commercial organization in a legal or commercial role knows, the dispute resolution provisions of a contract tend to be ignored or at least given very brief consideration during the negotiation of a contract. Most of the focus is on, I would say rightly so, on price, on payment terms, on other issues that drive the commercial bargain. It is nonetheless very important that those who negotiate contracts spend just a little bit of time and maybe a little bit of negotiating leverage on the dispute resolution provisions and the arbitration clause to avoid what we often see, and I'd say in the cases I've been involved here in this region in the last 9 years, a substantial percentage, probably 30 or 40% of arbitrations I see have arisen from an arbitration clause that is imperfect or worse, and that threatens the conduct of the arbitration and the enforceability of the award. That should be avoided. Now, the question I have for the panel, and then, of course, would love to have views of those in the audience as well, is in circumstances where you don't have all the time in the world or all the resources in the world, but you nonetheless need to get that dispute resolution provision right, do you have any tips or pointers you might offer to help parties understand how to manage their time and their leverage effectively, but still get what they need to create an arbitration clause or dispute resolution provision that is fit for purpose? Any thoughts on that?
Well, I think sitting in Qatar, I think it's fair to say that there have not been that many big arbitrations go through, in a sense, in terms of, and therefore I would expect that many of the senior management involved in Qatari companies or companies doing business with Qatari companies probably have not had the experience of an arbitration or two.
That's right.
And therefore, following that, I think it can be a little bit of a black box to some senior managers when they're finalising contracts. They'll very happily talk about the grounds for extension of time and variations and payment terms and other things, but when they get to that. And it's really the duty, it's my duty and our duty as advisors to patiently take them through something that should be transparent and discussed and understood. That's the most important thing from my point of view.
Chris?
I think my very short recommendation would be keep it simple. And if you're using institutional arbitration, go with the standard institutional clause without variation, or at least without extremely careful thought before you vary it. The reason being, you are less likely, if you do that, to run into the problems that Tom described of having a dispute about your dispute resolution clause, which is actually, I think, everybody's nightmare, unless you are a recalcitrant respondent and delay happens to suit you. Listening to Stephen describe his dispute resolution process at Qatar Rail made me think, wow, that's quite an incredible process, because you've tiptoed through countless minefields, and you've obviously done it in a very sophisticated and successful way. But if you...
So far.
But don't think that is straightforward. There are plenty of minefields there. What is in the jurisdiction of the expert? What isn't? What's the exact status of the expert's determination? What does binding mean? When is it final? When can you go to court? When you can start arbitration? Now that's a very complex structure. If you get it wrong, you can create a real problem for yourself. So I'm impressed I wouldn't, but I'm saying embark on that only when you really know what you're doing.
Just a brief observation. When you poke a balloon on one side, something pops out on the other side. So Stephen mentioned that it was not without effort to get where they got on their dispute resolution. It required substantial, probably upfront payment, cash flow, payment terms to allow people to decide that. So when you're altering from a standard, make sure you understand what that means for price, make sure what that means for the conduct of the project itself, which is obviously the key. Building the thing, delivering the thing is really the importance. I think going with the tried and true is probably the best way to do it. Something that's established to have worked well.
Thank you very much. I think we have time for one final question. I see a hand right here. Can we get the microphone to this gentleman there in the 6th row? 4th row.
Thank you very much.
One question.
Yes, just asking about adjudication. You mentioned in QRL you deleted the clause for dispute adjudication board from the FEDIC. And I believe when the contractor or parties have adjudication, rather than having the engineer who is part of the employer, it may reduce and maybe prevent the dispute, and also may reduce the contract price because there is some guarantee that there is a fair determination. So what's your idea about adjudication before going to arbitration? Thank you very much.
Stephen, do you want to comment on why, I mean, you must have considered it at Qatar Rail and you took
look,
the DABs out.
It's a very valid, when I said that we decided not to proceed with the DAB process, I'm not putting that down as a valid alternative. But when we looked at the landscape of what we were proposing, and we've got the engineer's decision, and then we've got senior executives and other things, and an opt-in expert, we just thought that was excess to needs and not appropriate for us. So that was our policy decision, holistically looking at our scheme. It might be completely appropriate for other projects.
Well, I can say I'm a great proponent of dispute adjudication boards and their use in projects, construction projects, of course, particularly. And in this region, unfortunately, they are very, very rarely used in the region. I have a number of views on why that is and why that should change, but that's a topic for another day. Indeed, it's a topic for tomorrow in Abu Dhabi. If you happen to be there, I'll be speaking at another similar conference on that topic. But they are a component of the dispute resolution process that I submit is underused in this region, and that should be changed. But we don't have time to discuss that now. What I'd like to do is firstly thank all of you for your time and attention. This is a wonderful turnout. I hope you've all found this session useful to you, and I'd like you to join me in thanking our panelists for their time and their preparation for today's session.
Thank you. Thank you.
Remy, any closing remarks? Okay. I believe there may be refreshments or something outside. We'll all be around for a little while and happy to answer any other questions.